Hello, this is Matt on the Moon Lambo channel, and I think I've found the only two lawyers on the entire planet outside of the SEC that actually think that XRP is a security. So presumably, they also think that oranges are securities in order for their logic to follow. So I wanted to share with you some stuff. One of them got a little bit snarky and rude with Attorney John Deaton, and Attorney John Deaton was not complaining, but I observed this to be the case. This individual was being rude and said to John, "You're clearly not ready for a debate," referencing this topic, the SEC versus Ripple case. And so I want to share with you what Attorney John Deaton had to say as to why it's just completely silly and ridiculous to think that SEC is actually an unregistered security of Ripple. But before going any further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto topics, but just as a hobby and just for fun. Also, I would like to mention that me covering this is in no way to be construed as an attack on these individuals. I think that from time to time, the way that some of these Bitcoin maxis in general we'll talk about Ripple, it's like they're trying to push buttons of people within the XRP community. But even so, I want to be clear, this is not some sort of attack on them, but I am going to challenge their ideas because I think that their ideas are not good ideas, but nothing against them personally whatsoever. So what set me down this path today? Well, let's take a look at this tweet from Stephen Palley, who is a lawyer. He's a partner, in fact, at law firm Anderson Kill. And he tweeted out the following. So you'll see, I think he's just trying to rile up the XRP community, but it is what it is. So he tweeted out, "The great thing about commenting on anything having to do with XRP that is not cultishly positive is that you get to see the full range or human stupidity in the comments." So there you go, just insulting the XRP community. And then his coworker, Haley Lennon, who is the other attorney, she is a partner also at Anderson Kill law firm, she responded to him and wrote, "Had to mute my phone yesterday." Okay. You'll see, I got a gem of a tweet from her in just a second too, by the way here. So I don't know what it is about like the Bitcoin, like the Bitcoin, I don't know if they're maximalists, but Bitcoin maxi types and just really gung-ho Bitcoin people. I don't know what it is about them that just makes them think that it's reasonable to like push the buttons of other communities, specifically XRP, because the XRP community is the most attacked crypto community on the planet, as evidenced by these individuals right here. Stephen Palley, he was covered in this article from FX Street. This is from January of last year. You can see that I don't need to read the article, but just get you a little taste here. Crypto lawyer Stephen Palley affirms Ripple is a security while XRP price struggles to recover. Now, when they say Ripple, they actually meant XRP there. And then there was also this headline from the Daily Hodl. "Here's what Ripple can do to save XRP according to crypto lawyer Stephen Palley." And here's a quote from him. "For XRP to survive, Ripple needs to cut a deal with the SEC and not persist in the risible delusion of ultimate success in the U.S. Supreme Court and substitute the Ripple test for the Howey test. There are 600 million reasons why I'm right. If they care about bag holders, that's the path." Now, look, I actually do agree as far as Ripple test replacing the Howey test. I don't see that happening. I don't even want that to happen. That'll probably take 5 to 7 years going to the Supreme Court. No. I don't want that to happen. I don't think it's going to happen. But to think that the only path forward is for Ripple to cut some sort of deal, I don't know. Have you been paying, well, you listening, I bet you have been paying attention to all the facts and circumstances surrounding this case for the last year. Not looking good for the SEC. And I think if fully adjudicated, Ripple comes out better on the other side of this thing. And the SEC could potentially even lose power as a result of Ripple's fair notice defense should they be victorious on that front. But this is what's being argued here. And then there was this from Stephen Palley. He wrote, "There was much hullabalooing by Ripple fans about the denial yesterday of a motion that strikes Ripple's fair notice defense by SEC. Procedurally, that was unlikely to happen. Not hullabalooed was the court's same-day denial of Garlinghouse and Larson's own motions to dismiss." So he seems to think that Ripple being allowed to argue the fair notice defense in court isn't that big of a deal. And then he goes on to cite that the cases against Garlinghouse and Larson not dismissed. I covered that. I cover news whether it's good or bad. But it's just, do you see the tone here from these people? Look at the tone. And so there was an individual named Tag XRP, who I highlight on the channel from time to time, who tweeted out something from Haley Lennon. and because she had shared that tweet from Stephen Palley, and Tag XRP tagged John Deaton and said, "Curious, any thoughts on this?" And John Deaton did respond, but first I'm going to share with you a couple comments from an attorney within the community who just goes by the name Crypto Counselor and wrote, "A lot of what he says is true." So referencing Stephen Palley there. "A lot of what he says is true, but he neglects to even consider the risk posed to the SEC, nor that this remains on the table. This is a huge risk to the SEC, since winning on the fair notice defense would then greatly hinder the SEC in every and all future crypto litigation." My response, I know John Deaton would have been nicer in his response, but that guy is just a Ripple hater, and from the other stuff he's posted, I'm convinced he's not a licensed attorney. So digging back a little bit here. And look, I don't know what it is that makes Stephen Palley and Haley Lennon absolutely despise Ripple and XRP, but it comes across in anything that they have to say on the topic. They despise it, and I think they're going to be proven to be on the wrong side of this thing when everything's all said and done. And so the other tweet from Crypto Counselor reads as follows. I'll have to censor it a little bit. "Pretty sure this guy isn't a practicing attorney, and if he is, he's a effing idiot for not realizing the leverage this gives Ripple. The fair notice defense remaining on the table is the biggest risk to the SEC in this case, as it would apply to basically all other cases." And here's a tweet from attorney Haley Lennon, that you can see that she's comparing the physical attractiveness of the two individuals on the screen, and she wrote Bitcoin versus Ripple. So, okay, there you go. You can see the hatred for Ripple here. And so Matt Hamilton, who is a Ripple employee, resaw that and responded as follows. "I do genuinely wonder what your issue with Ripple/XRP is. I mean, I guess you dunk on it because it makes your tribe happy, right? What would it take for you to decide you actually wanted to understand how cryptocurrencies work? I'd be happy to chat if you want." And this is when attorney Haley Lennon responded and wrote, "I think it's a security and will be deemed as such." So there you go. She thinks that XRP is a security and will be deemed as such. Presumably, she also believes that oranges are securities. It's the very nature of the asset existing that makes it a security. That's what she seems to think. And Matt Hamilton responded with the following. He wrote, "Interesting. Your tweet compared Bitcoin to Ripple, so I'm guessing you are still having trouble understanding the difference between a company and a cryptocurrency." That does indeed seem to be the case. And so, again, Tag XRP asked John Deaton, "What are your thoughts on all of this?" Right? And here's what attorney John Deaton had to say. "A lawyer offering the opinion that XRP will be deemed a security, but doesn't distinguish between specific and early sales of XRP, like 2013 through 2017, offered by Ripple, versus secondary market sales of XRP independent of Ripple, is either unfamiliar with the allegations or is hedging her bet. For example, if the jury or court decides Ripple violated Section 5 of the Securities Act between 2013 and 2018 because XRP at that time constituted a security, but finds today's XRP, including secondary market sales of XRP, are not securities, is the prediction accurate? The denial of the motion to strike and the denial of the motions to dismiss were decided as expected. The motion to dismiss Garlinghouse and Larson was filed over a year ago, and the judge assumed that all the allegations in the complaint made against these defendants are true. In other words, the judge doesn't consider any of Brad or Chris's defenses with this procedural motion to dismiss. There was less than a 1% chance Brad or Chris would win the motion at this stage. The SEC's motion to strike the fair notice defense was substantially similar. The judge assumed everything contained in Ripple's answer to the complaint is true. The SEC had a 1 to 5% chance the judge would grant it at this stage. She was only deciding whether Ripple can argue the lack of notice as a defense, not whether Ripple will be ultimately successful. Yeah, so that's the thing that I've been noting on this channel again and again here, just so there's no confusion. The judge did not say that Ripple did not receive fair notice. That's not what the ruling was the other day. The ruling was that Ripple will be allowed to argue that they didn't have fair notice in the court case. That's it. But that's huge. Again, that is huge. And then John said, "I've said multiple times that the fair notice defense is ultimately the most important issue in the case for Ripple and the SEC, but I never thought for a second the judge was going to strike the defense on the pleadings alone and not allow Ripple to develop a full record. Because I viewed the motion to strike having practically no chance, I've always maintained Judge Netburn's decision regarding the 63 Hinman emails and the Estabrook notes as much more significant. Now, in response to that thread, Haley Lennon apparently not thrilled that Attorney John Deaton has a different perspective than hers and that she wasn't tagged, and she wrote the following to John Deaton. Tag me next time you do some post about me, and then we can chat. You're clearly not ready for a debate. So I don't know why she's so offended just by John Deaton politely and in an adult fashion just sharing his perspective, which is different than Haley Lennon's, but she did seem a bit offended there and defensive. And it's not like, it's not like John Deaton is required to tag everybody. Although I will say this, when he writes threads, typically, whether he's saying something positive or negative about somebody, he does everything in a professional manner always, but he will tag everybody. He is not afraid to tag people. He happened to have not tagged Haley here. That doesn't mean anything. He tags people all the damn time, from Gary Gensler on down. But anyway, in response to that, and again, Haley said, "You're clearly not ready for a debate." To John Deaton, John wrote the following. You seem defensive. No one attacked you. I was asked to comment. My point is, what is the opinion? Is it that XRP was a security in early years? If so, I may agree. If a lawyer supports the nonsense argument the SEC is arguing, then I don't. And if that was a challenge, accept it. And it's so funny here that she seems offended, and she's going out of her way to offend XRP holders. Again, I shared you through the tweets from her, including her comparing Bitcoin versus, as she wrote, Ripple, she meant XRP, with the pictures of the two men. It's just so rich, isn't it? Is it not rich? So Haley then responded to that and wrote, I posted my opinion in my response. You said an attorney commenting is either unfamiliar or hedging their bets. I'm neither. And then John Deaton responded and wrote, you said it's a security and will be deemed one. If that means today's XRP sold in the secondary market free of Ripple will be deemed a security, you're not hedging your bets. If that's your belief, despite you not thinking I'm ready, we can set the debate ASAP and help me prepare me as amicus. And after that, Haley Lennon went radio silent, and that was 19 hours ago. So methinks that she doesn't want to debate John Deaton, and I don't think it would go well for her if she did debate John Deaton on this topic. And so then Chip from On the Chain YouTube channel wrote to John Deaton and said, we would love to host the debate live on our podcast On the Chain. Are you game? John Deaton wrote, of course I am. Live is the only way to do it. Chip then tagged Haley and wrote, Haley, do you accept the live debate challenge? Come on, it will be fun. And again, no response. I'm not anticipating this will happen, but yes, it would be fun. And John Deaton, come on, he's a nice guy. He's not going to be rude. He hasn't been rude to you, Haley. Not that you're listening to this, but why not? Go on, have a friendly little debate with John Deaton. Have a discussion here. It's not going to happen. I mean, I personally don't think that it's going to happen anyway. Oh, man. And then there was this from attorney John Deaton. There's a valid reason XRP holders are celebrating the judge's denial of the motion to strike Ripple's fair notice defense. Critics fail to see the big picture and instead focus on legal nuance. The reason XRP holders are celebrating is because they believe Gary Gensler will not risk a decision by the court finding the SEC's own lack of clarity, inconsistency, and confusion related to regulating the digital asset space caused a lack of fair notice to the market. If the court were to make such a finding, and that's a big if, it could have a huge impact on the SEC's ability to regulate this space. XRP holders see two possible options for Gensler. Number one, Gensler can achieve a settlement for a significant sum, i.e. $100 million or more, thus providing him a huge public victory with bragging rights allowing him to say he held Ripple accountable for sales of XRP during the early years while allowing innovation to move forward. Or number two, risk a ruling which, at best, will embolden other projects in this space to fight versus SEC, or at worst, relegate its jurisdiction to ICOs only. Many believe he will choose the first option and not risk a huge loss. He could claim victory while focusing on his next crypto target. And so that's, and we all understand this. For some reason, these other two attorneys, Haley and Steven, they don't seem to share that perspective from what I have gathered to this point. And they do seem to think XRP is actually a security by the very nature of it existing. Again, don't know why they hate Ripple and XRP so much, probably because reasons. but their tweets are not going to age well. I really don't think that they're going to age well. But I'll go ahead and wrap up there. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.